Hello, everyone. I'm not sure if you heard the few comments that I made, so I'll start over. My name is Olivia Holcombe-Volke, and as Jeff said, I am a partner with Elville and Associates and primarily focused in estate planning and elder law and special needs planning as well. And I just want to say how thankful I am that we are able to proceed with today's presentation, even with the public health crisis. Modern technology is making this possible, and for that I am very thankful. And something that I've been thinking a lot about is that I don't know about all of you, but I have very much been feeling like all of the things that I am not able to do and all of the freedoms that I am not able to enjoy, all of which I was used to before this situation really hit. Focusing on those things that I cannot do does not get me anywhere. And so I am doing everything I can to try to focus on what I can do. And an example of that would be an estate plan. Whether you have an estate plan that needs updating or you don't have an estate plan at all, that would be an example of something that can be done during this very difficult time. The topic that I will be going over today is a discussion of the essentials of estate and elder law planning. And when I talk about estate planning, often people think of that in terms of what happens to my stuff when I die. But the reality is that estate planning actually covers more than just that. And I would argue that the additional pieces that are covered under the moniker estate planning are actually equally important because it deals with what happens to me and my health care and my money and property in the event that I become incapacitated. Talking a bit about why planning is so important. And the reality of it is that whether you're thinking about what's important for your own benefit, or you're thinking about it from the perspective of what's important for the sake of your loved ones, or the people who will be taking care of things for you when you are not able to. The reality is that having a plan in place makes things ever so much easier when someone is taking care of things for you. So having documents in place that not only dictate what you want to happen, but also who you want to handle those things for you helps take away one additional area of grief during a time when a family member or a friend or a professional is helping take care of things for you, either while you are incapacitated or after your death. Having a document in place that gives them an outline of what they are to do and that actually gives them authority to do so helps give them guidance, streamline the process, minimizes the costs actually, and allows you to actually provide for special purposes or special intentions that are important to you, none of which will happen if you don't have written documents in place. So first, I'm going to talk a bit more about what I mentioned, which is incapacity planning. And this is the aspect of estate planning that many people aren't familiar with or that they aren't thinking about as often as they are thinking about what happens after death. But incapacity planning is just as important. And when we're talking about incapacity planning in an estate planning context, what we are really talking about are documents called powers of attorney, advanced medical directive, and the MOLST form, which stands for Medical Orders for Life-Sustaining Treatment. To start out with why incapacity planning is so important, it's not only so that you are able to actually have some form of control over what happens and who will handle it in the event that you become incapacitated, but most importantly, it is for the sake of avoiding guardianship. And what I mean when I say that is that many people are familiar with guardianship in terms of minor children, but guardianship is also an applicable term to adults. And it is a situation where if an adult who loses their mental capacity and is no longer capable of managing their own decision-making, whether with regard to their health care and or their property and money, if that adult did not sign documents giving another person the authority to act on their behalf, then what ends up happening is that the court gets involved and a guardian is appointed by the court to manage the disabled adult's healthcare and physical well-being, as well as their property and money and financial well-being. And guardianship, because it is a court process, involves the court supervising all of the decisions and actions that are taken by the guardian. It's a public proceeding. It can be expensive. It can be embarrassing. It can be painful. And so it's not something that any thinking adult ever wants to go through or ever wants their family to go through. And the way to avoid that is by making sure that you have the necessary incapacity planning documents in place. And something that I like to emphasize, because I find that often people have an assumption about this that is actually not entirely accurate. Even if you are married, it is vital to have these documents. It is not a guarantee that just because you are married, your spouse will automatically have all rights to make decisions for you, or even more important, to be able to access your assets and do what might need to be done with them for your benefit. So even if you are married, these documents are vital. Talking a bit more about the avoidance of guardianship, the purpose here is really that you, while you still do have your mental ability, have made the decision for yourself about who you wish to give power over your assets and over your finances, and you've decided who you wish to give authority to talk to the doctors and make healthcare decisions for you if need be. So you have actually made the decision about who that person will be and who the backup agents will be. You have also been able to put into writing the parameters of that authority and to actually give instructions on what you want done, especially in a healthcare context, and also to be able to limit powers to a certain extent if you don't want the person who you've named as your agent to be able to do anything and everything. The only way that any of that is going to be written in a way that is in line with your intentions, your concerns, your goals, is by actually having written documents where you've set forth those parameters. So beginning with talking about healthcare decision-making, and here the document that is used in Maryland is called the Advance Medical Directive. This is known frequently as a healthcare power of attorney. Many times people ask me, is this the same as the living will? And the answer is that the Advance Medical Directive form in Maryland incorporates both what is known as a healthcare power of attorney, which is the piece where you can actually dictate who it is that is going to be your voice to the doctors and to actually make the decisions that need to be made. But it also includes the portion that's called the living will. And that's where you are able to actually give instructions about what you want done with your health care in the event that you are in certain end-of-life situations. Now, in Maryland, there is no required format for an advanced medical directive, but we are lucky enough to have significant input and guidance by the Attorney General of Maryland. And so the form that the Attorney General has created really covers all the bases and allows us to use it as a good foundation that we can then add to for each particular client to make sure that they have an advanced medical directive that covers and addresses their concerns and the information that they want to make sure their healthcare agent is aware of. In addition to making the personal decision about the actual human that you would want to be your voice to the doctors and to be the one who would have the responsibility to make certain decisions about your health care, the Advanced Medical Directive also allows you to outline at what point does your healthcare agent have the ability to speak up on your behalf. And many people believe that this is, by default, something that is only triggered upon incapacity. With the healthcare document, the Advanced Medical Directive, it is absolutely true that your healthcare agent cannot replace your voice as long as you still have your voice. So at no point does your healthcare agent rid you of your autonomy. But there is a slight distinction that the document allows you to address, which is whether you want your incapacity to be determined simply by the matter of fact of you no longer being able to speak for yourself, or whether you actually want to take an extra step and require that your incapacity first be certified by doctors. And that's just a slight nuance, but it's an important one. And that's part of what I counsel clients on as we go through the document and personalize it according to their preferences. The Advanced Medical Directive also allows you, as I mentioned previously, to give certain end-of-life treatment instructions. The living will specifically deals with terminal condition, persistent vegetative state, and what's called end-stage condition. And it allows you to let your healthcare agent know what you want done if you are ever in one of those situations. Now, people often ask me, is this the DNR, which stands for Do Not Resuscitate? And the answer to that is no. That is actually contained in a separate document, which I will go over next, which is called the MOLST. The Advanced Directive does not deal with situations where you may or may not need to be resuscitated. The purpose of the Advanced Directive is for you to empower another person with the ability to tell the doctors whether or not you want to receive food and fluid by tube or other means, or whether or not you want to be kept on a ventilator in the event you have a terminal condition. Those are the sorts of considerations and the sorts of information and instructions that actually go into the Advanced Directive. It also allows you to talk about things that are perhaps not clinical instructions, but more personal to what your vision is of your end of life. Whether that is, I want to be able to listen to classical music, or I don't want to be in a room with the television on all the time. Or I had a client recently who said, I want vanilla ice cream and my dog to visit. These are instructions that people who are taking care of things for you at a certain point in life may not know about your sense of joy or peace or comfort. So I always recommend that clients take that into account. And whether they actually include instructions like that in the Advanced Directive, or even write a separate personal letter, a letter of instruction to potential future caregivers or people who are going to be involved in your life at that stage, so that they will know some of those ancillary details that may be as important to you as the clinical instructions. Finally, the Advanced Medical Directive does allow you to dictate whether or not your healthcare agent has discretion. So you can choose to say, I've given my instructions in this document. However, I will allow my healthcare agent the discretion to make a different decision in the moment if they think it's in my best interest. Or you can choose to not give your healthcare agent that discretion and simply say that they have to follow your instructions exactly as you've written them. Finally, the Advanced Medical Directive allows you to speak to whether you wish to be an organ donor or to donate your body for use in a medical study program. And finally, what you wish to be done for your final arrangements, whether that's funeral, burial, cremation, memorial service, whatever your preferences may be, this document provides you with the ability to outline those. Now, the MOLST. So as I mentioned, this is really the document that covers the DNR, the Do Not Resuscitate Order. And the MOLST form, which the acronym stands for Medical Orders for Life-Sustaining Treatment. This is actually a medical order. So this is not signed by you. This is a medical order that will be or would be signed by a physician if you are in certain medical situations. But what you are able to do, even though you cannot sign the medical order, you are able to complete what's called the Healthcare Decision-Making Worksheet. And that's a document I always recommend that clients complete and that they keep a copy with their advanced directive. And it is in the Healthcare Decision-Making Worksheet that you are able to actually give instruction to some future physician who may be signing a MOLST form on your behalf to let them know whether or not you want to be resuscitated. That is a document that goes into much more medical expertise than any estate planning attorney is really able to offer. So my recommendation is always simply to provide the client with knowledge of MOLST and knowledge of the Healthcare Decision-Making Worksheet, and then to recommend that they actually speak to their primary care physician regarding the form. Now, that is healthcare. Separate from that is the financial aspect. And again, we are still talking about while you are alive, but potentially incapacitated. Although, with the financial powers of attorney, it is not dependent upon whether you are incapacitated or not. And I'll speak to that a bit further in a moment. A financial power of attorney is only effective while you are alive. Again, the purpose is for you to be able to actually designate another person with the authority to access your money, your bank account, your 401k, your life insurance, any asset that you own. The purpose of a financial power of attorney is to give another person the ability to access those assets on your behalf while you are alive. And the overarching goal is to avoid and protect you against the risk of guardianship. So that's why this document is also so important, because it allows you to actually control who is the person that would be able to access my assets for me if they ever needed to, or if I ever needed them to, or ever wanted them to. Financial powers of attorney are actually accomplished utilizing two forms. At least that is the case when you work with an estate planning attorney, and I'm going to explain why it's so important to do it that way, why we do it that way, but I will emphasize that it's something that you will not find if you are simply trying to do this on your own. The two financial power of attorney forms are something that an estate planning attorney can provide to you and can help walk through both documents, what they cover, and why both of them are so important. But briefly, the first form, financial power of attorney, is called the Maryland statutory form. That is because it comes out of Maryland statute. The legislature recognized in the last 10 years that there was no standardized form financial power of attorney. And as a result, people were often writing their own. And as a result of that, banks and other financial institutions were often rejecting the forms, leaving the people who had signed them without a power of attorney, unprotected, and potentially exposed to guardianship. So the legislature stepped forward and actually created a standardized form, financial power of attorney. And in the statute, in the law, it says if you use this form and you don't change the language, all that you really change are the names of the people. But otherwise, you leave the language as the legislature wrote it. If you do so, it is mandatory that banks and other financial institutions accept it. So it's an extremely powerful document, which is why it is always the first and foremost power of attorney form that we use. But it also means that there's limited customization other than, as I mentioned, the names of the people that you're actually giving this power to, and effectiveness, which we'll talk a bit more about, meaning at what point is this person's power effective. The second power of attorney document is called a general durable financial power of attorney. And that name can sometimes be confusing. It does not mean that the Maryland statutory form is not a general financial power of attorney or that it is not a durable financial power of attorney. It is both of those things. But this title for the second document is just kind of an easy way for us to keep track of which one we're referring to, the Maryland statutory form or the other one. So referring to the other one, the purpose of it is to supplement the Maryland statutory form. So the second financial power of attorney document does not replace the Maryland statutory form. It does not revoke the Maryland statutory form. It supplements it, which means that it has the same listing of people that you want to name as your financial agent. And with any of this, any time I've mentioned naming someone else to act as your agent, I encourage that you always name at least one or two or three backup agents in the event that your primary one is not able to act for you. Because we want to make sure that if you're going to go through the machinations of doing this sort of document and planning, that you've actually got sufficient people in place so that you continue to be protected even if one of them is unavailable. So the second financial power of attorney will have the same listing of agents, and it will have the same effectiveness, which again we're going to talk about on the next slide. So what is the purpose of the second financial power of attorney document? And the answer to that is the Maryland statutory form covers about 95% of situations that may ever come up, and it provides about 95% of the powers that your financial power of attorney might need to be able to act on your behalf, but it does not cover 100%. And we, in our practice in estate planning and especially in elder law, we are aware of the fact that that 5% of missing powers from the Maryland statutory form can actually be very important. And those powers are covered in the second financial power of attorney document. And to briefly go over what those extra powers really entail, I will say this. They are the powers that are primarily needed in terms of doing any sort of elder law asset protection planning. So the extra powers that are in the second financial power of attorney deal with giving your power of attorney the ability to create trusts for your benefit, to establish trusts for your benefit using your assets, and the ability to make gifts from your assets. So the power to gift. And that is primarily utilized in terms of asset protection planning and certain Medicaid spend down or other strategies that are sometimes necessary in light of increased medical costs. But that power to make gifts is also something that can be useful in terms of doing tax avoidance, in terms of thinking about estate tax versus gifting while still alive. And the final power that's extra in the second power of attorney document deals with compensation. You may think that under the law, someone acting as your financial power of attorney has the right to receive compensation for their services. That is actually not true. It is not covered under the statute. So in order for your financial power of attorney to have any way to receive compensation, which sometimes can be very important and is something that we recommend, although it's not always a good idea for everyone, but it's a good idea to have a conversation about it. And the compensation clause is something that is contained in that second power of attorney document. So those are the additional powers that are included and the reason why we recommend doing the supplemental financial power of attorney. Now to talk a bit about effectiveness. So as a starting point, I will say most people think that a financial power of attorney is only effective upon incapacity. So if I, Olivia, sign a financial power of attorney giving someone else the right and the power to be my financial power of attorney, the assumption is that that would only be effective if I, Olivia, lose my mental capacity. That is actually not true. The default under the law is that a financial power of attorney is effective immediately. So the moment I, Olivia, sign it, the person that I've named as my power of attorney has the authority and the ability to take that power of attorney document to my bank and say, I'm power of attorney, I have the right to access Olivia's bank account. When I tell people that, you may not find it difficult to believe that causes most people to feel quite a bit of panic. And I always try to calm that down by talking through a few things. First of all, having immediately effective powers as power of attorney does not mean that I, Olivia, have given up control or access or authority over my assets. I am not giving up control and giving it to another person. I still have full control and full autonomy and full power and authority over my assets. But my power of attorney does too. Why would that ever be useful? Well, one example is that if in a future world, when we are able to actually leave and travel and go places, I may be somewhere far away and need something local signed or handled. If my power of attorney is effective immediately, that person would be able to do so for me. Another example of why it could be a good idea to have it be immediately effective is actually reflected in these current situations. What if you are in a situation where you cannot leave where you live and need something done at the bank or need something signed or handled out in the world? If your financial power of attorney is effective immediately, that person will be able to do so for you. So it does have some utility. And another thing I always like to emphasize when people feel concerned about a financial power of attorney being effective immediately, I always think it's worth having the thought exercise. Why are you more comfortable with that person having power over your money when you are incapacitated than you do when you have your mental capacity? Because I personally, Olivia, would prefer to actually observe whether the person that I've named as my financial power of attorney is somehow misbehaving and is somehow spending my money or doing things with my assets that are not in keeping with their responsibility, which is to act for my benefit. So for that reason, I sometimes think, why is it that you would be more comfortable having that person have power only when you are incapacitated, when you are not able to actually supervise their actions? And all of this goes back to the argument that what matters the most is that the people you are giving this power to, you trust completely, and you do not have concerns that they are going to misbehave. All of that being said, you do have the ability to change the effectiveness. It does not have to be effective immediately. You have several other options, one of which is that we can actually edit the document and say, this power of attorney is effective only upon my incapacity as certified by 2 physicians. Or an alternative option is that you sign the document so that it is immediately effective, but you don't take any originals with you. We hold all of the originals for you, and you sign an escrow agreement with us that basically says we will only release the original power of attorney document either if you tell us to or if your named agent provides us with proof of your incapacity. So there are variations on how you can render the effectiveness, and it's just a matter of discussing your particular concerns and situation and preferences. Now, moving on to the portion of estate planning that most people think of, which is what happens after death. And here I'm going to talk about what many people are familiar with, which is what's called a last will and testament. And I'm also going to talk about something called a revocable living trust. Starting with a last will and testament. A last will and testament is a piece of paper, it's a document, and it dictates where you want your property to go when you die and who you want to handle it. That person is sometimes known as an executor. In Maryland, they are known as a personal representative. So a last will and testament, it's a document. It says where you want your stuff to go when you die, and it says who you wish to handle it. But the piece that many people don't realize is that the last will and testament does not mean anything until it is submitted to the court after your death, and the court, called the probate court, has the opportunity to review the will, to allow the public to say, wait a minute, we don't think that's a valid document, or we think that person was under the influence or was unduly pressured. It gives the public the opportunity to basically challenge the will and the validity, and it's only after that that the probate court says, okay, this will is valid and it can be carried out. And it is the probate court that actually gives authority to the will, and it is the probate court that actually gives authority to the personal representative. So many stories of this situation where the person named as the personal representative goes to the bank with a copy of the will after the person's death and gives the bank the will and says, give me the money. And the bank says, go to the probate court. So a will does not have any validity or effect until the probate court has given it that. And that means that the term probate, which many people have heard or are familiar with, probate is what is relevant to when you have a last will and testament as your estate planning document. Probate, as I said, is a court process. It is subject to public oversight. As crazy as it seems, anyone from the public can go to the probate court and ask to see a copy of the will and ask to see a copy of all of the documents that are relevant to the estate. It is entirely public. And unfortunately, because the court is involved, that can slow things down because the personal representative is dealing with the court timelines and the court availability. So the probate process involves not only opening the estate by filing the necessary paperwork, including the will, but also providing the probate court with an inventory of all of the assets and allowing for there to be sufficient time for creditors, that is, people to whom the deceased person owed money. There has to be sufficient time given for creditors to make a claim against the estate. And the probate court requires an accounting, which means that every 9 months they have to be provided with an actual accounting of all assets that have come in and gone out of the estate. So the entire process is subject to court oversight, which means that there are also court fees that have to be paid. And it can be a nuisance because the personal representative has to check in with the court on pretty much all of their actions. As a result of this, we do find on average that it does tend to be true that the cost of probate ends up being around 4%. 4 to 7%, but 7% is really on the high end. I usually find on average 4% of the size of the estate is what ends up being eaten up through the costs of probate. When someone chooses to use a last will and testament as their estate plan, what their full estate plan looks like is the will to deal with after death, but also the advanced medical directive and the powers of attorney that I went over previously that deal with incapacity planning. Now to talk about the revocable living trust. And this is the easiest way that I usually say this is that a revocable living trust is a substitute for a last will and testament. So I always recommend that just for simplicity's sake. It's much more, there are many more details to it. It is something that requires much more education from your estate planning attorney. But the simplest way to think about it is that a revocable living trust is a document that takes the place of a last will and testament. And as a result, what you accomplish by doing a revocable living trust is avoidance of probate. And this is the thing that most people make their decision based upon. It's a matter of, do you want to set up your estate to avoid probate at your death so that the person or people who are handling things after you die and who are standing to benefit from your estate after you die don't have to deal with probate? And if the client's choice is, yes, I want to set everything up to avoid probate, then the solution most of the time, and I have to always give a caveat, I'm not saying that 100% of the time any of these are always the right decision, but most of the time the answer to avoiding probate is to do a revocable living trust. So what is a revocable trust? Because that's also often very confusing. Just like a will, a revocable trust is a piece of paper that says what you want to happen with your stuff when you die and who you want to handle it. And that person will be acting as the trustee. The difference between the revocable trust and the will is that the will is just a piece of paper. You sign it, you put it away, you don't think about it until after your death, and that's when it kind of comes to life. A revocable trust, on the other hand, after you sign the document that says what you want to happen with your stuff when you die, the next step is that we actually take your assets and we retitle them into the revocable trust. This is called funding or asset alignment. While you are alive, because I find many people say, whoa, I don't want to retitle my assets. I want to continue to own my assets. The revocable trust, while you are still alive and while you still have your mental capacity, the revocable trust is still under your control. You are the trustee. And while you are alive, you are the beneficiary. All of the money and the property owned by your revocable trust is for your benefit and under your control while you are alive. And it is associated with your Social Security number. So there is no change to your tax filings. But what happens when you die? The revocable trust does not die. It's not human. It's an entity. So what happens when you die is that the revocable trust becomes irrevocable. The person that you've named to be the successor trustee steps up, and they turn to the page in the revocable trust that says where you want your property to go at your death, and they carry it out. And none of that has to go through court, and none of that requires probate oversight. I always want to emphasize that a revocable trust does not give you creditor protection or asset protection while you are alive. What it does is it avoids probate. It also does not avoid taxes. So a revocable trust is done to avoid probate, not to give you asset protection and not to avoid taxes. And on average, we do find that the cost of trust administration usually ends up being about 2% of the size of the estate. So when a client chooses to do a revocable trust-based estate plan, again, they will have an advance medical directive and powers of attorney. They will also have the revocable trust. They will also have documents called assignments, which is part of the funding. And they will have a last will and testament. It's called a pourover will, and the purpose of it is simply to act as a safety net in case there was an asset that was not properly funded or aligned with the revocable trust. And as a result, at death, it had to go through probate. Then we want to make sure that there is a will to control where the probate estate will go. And what it will say is that at the end of the probate process, it goes to the revocable trust. So it's called a pour-over will because it pours over into the revocable trust. And the purpose of that is to ensure that all of your assets are structured properly to go according to the decisions that you made about where you want your estate to go at death. So we do a pour-over will as a safety net, but if we do our jobs correctly and you make sure and let us know every single asset that you have, we make sure it is fully funded with your revocable trust, and so the pour-over will serves no purpose. Now, there are other devices that can be used to avoid probate. And many of these people have heard of, they are familiar with, and so I always want to mention them. And what I mean when I say this is that these various forms of asset ownership or having assets structured in a certain way, these will also accomplish avoiding probate at your death. And examples are joint ownership, which is where you and another person or you and more people all jointly own an asset. Most of the time, again, a caveat here, there are nuances, but for the most part, when any property or asset has joint owners, if one owner dies, the survivor is the owner. It does not have to go through probate. And you are able to do things like make accounts payable on death, POD, or transferable on death, TOD. Those types of structures will avoid probate. At your death, the person who the money is supposed to go to provides a death certificate, and the bank or other financial institution issues a check for the money, and that does not have to go through probate. And that is also how a beneficiary designation works. And of course, that's something many of us are familiar with regard to certain types of assets, like retirement plans, 401ks, IRAs, 403bs, annuities, and also life insurance. Those are special types of assets that are handled by the beneficiary designation, which is where that money will go at death. And life estate deeds are another example, a form of deed on real estate where an owner who is named as the life estate holder has the right to own the property as long as they are alive, but at the instant of their death, it goes to the remainder person named in the deed. What I will say about these various other non-probate devices is that they are useful in some capacity, but that they are not to be relied upon completely as the only form of a state plan, because there are various things that can go wrong. And two simple examples of that are, people sometimes say, well, I'm going to add my adult children to my bank account as joint owners. And that way, not only will they be able to access the money while I'm alive if I need them to pay my bills or do something for me, but they'll also be the owners of the money at my death without needing to go through probate. The problem with that is that when people do that, if their adult child then gets in a car accident and gets sued and is found responsible, the money that's in that joint bank account, which was originally the parent's money, can now be taken by the creditors of the child. And that was not anyone's intention, and that certainly is not what you would want to happen. So that's a risk with joint ownership. And the way that that can be, the goals of that can be handled without adding in the risk of the joint owner's creditor being able to take everything. During lifetime, your financial power of attorney can access your bank account if they need to act for you. So that's where you would name, for example, your adult child as your financial power of attorney. And that accomplishes the goal of them being able to access the money while you are alive to take care of what you might need. And then with regard to what happens after death, if your goal is that that money goes to your adult child without probate, the way to do that would be to do a revocable trust. Now, when you do wills or when you do a revocable trust, we sometimes may still have you do these other non-probate devices. There are circumstances where you will have both the revocable trust and a POD asset. But I do not ever recommend relying only on doing joint ownership or payable on death or transferable on death, any of those sorts of structures without a bigger document to back everything up. And another example of what can go wrong is if you made an asset POD, let's say to your adult child, and at the time you die, your adult child is in the middle of going through a divorce. And now the money that they get from your POD account can be potentially divided with their divorcing spouse, all because the timing was wrong. Those are examples of the ways in which you would be giving up control over addressing contingencies that may be happening or may be possibly happening at the time of your death that you just have no way of predicting. So that's why we don't recommend relying on these devices alone. Now, part of what I said I would cover is elder law. And what does that really mean? And what I find is a useful exercise is to distinguish what is the difference between estate planning and elder law, or estate planning and elder care planning. And the reality is that there is significant overlap. There is not a lot of distinction. Often the distinction arises in the client's motivation. So when we're talking about someone who maybe believes that they are late in life and that they are not far from what could be an incapacity situation or could possibly be a death situation, we really are talking about doing things that are both estate planning and elder care planning. Whereas typically for people who are maybe younger or healthier, when they do estate planning, they're really thinking about it in terms of, this would just be to deal with my assets if I died. I have a minor children and I want to make sure they'll be taken care of, so that's why I'm doing estate planning. And they're not usually thinking of it in terms of elder care planning because they're just not at that stage in life, although it can certainly happen to anyone at any time, the need for increased medical care. But estate planning is what happens to my stuff when I die, and who is it that will help take care of things for me if I'm still alive but incapacitated. Elder care planning and elder law covers all of that same ground, but it also sometimes takes into account the reality that there may be increased medical costs at some point soon, and the discussion, therefore, of what possibility there is for preserving assets, for protecting assets in light of possible increased medical costs. And that discussion always involves discussing whether there are possibly veterans benefits that a client may be eligible for based upon their own service in the military or their spouse's service in the military. There are veterans benefits that are available in certain situations, and also sometimes the conversation about Medicaid benefits and the eligibility that may be possible for that. When we're talking about asset preservation in the long-term care context, we're really talking about at any phase of life, given that none of us know if and when the worst may happen, which is that we need the highest level of medical care. And as a result, all estate planning includes elements of what's called pre-crisis planning, which is making sure that you have the necessary documents in place to ensure that if you are not able to take the actions for yourself that might need to be taken, such as irrevocable trust planning to protect assets, or otherwise doing some sort of gifting strategy to protect assets. Pre-crisis planning means that you're saying, I can do anything and everything I need to do for myself right now, but I'm going to go ahead and make sure I have the documents in place that will provide those same powers for asset protection and crisis planning. I need to have documents in place that provide those same powers to someone else to be able to do for me in the event that I'm not able to. And that's what pre-crisis planning means. And all of those powers that are necessary are covered in the financial power of attorney documents that I mentioned. And if a client does a revocable trust, they are also covered in that document. So pre-crisis planning is something you will accomplish purely by doing an estate plan. There are situations where Medicaid is relevant. There are situations where veterans benefits are relevant. And in those situations, then it becomes necessary to do an analysis of how to be eligible for those benefits and whether or not it's worthwhile. But one option to become eligible for benefits of that type is using Medicaid asset protection trusts and veterans asset protection trusts. There are also examples of where we may implement a last will and testament for a client that will leave a trust for their spouse who may be sick or disabled. So that's another tool that sometimes we do rely upon. Crisis planning is where we're talking about not a situation that may happen in the future, but a situation that is now. And really, the best way you can have any sort of crisis plan is if you've set up the documents as part of your pre-crisis plan. But even in crisis moments, especially when clients actually have the necessary financial powers of attorney and advanced medical directive, and in best cases, the revocable trust, even in a crisis, we're able to implement whatever plan may be best for that particular client in that particular situation. And life estate deeds are sometimes used in these situations, particularly if someone's only asset is a piece of real estate. But as I say, all of this requires counseling and guidance and conversation with me or another experienced estate planning and elder law attorney who can help guide you on your goals, your concerns, your assets, and what the best plan will be for you. And with that, I will take any questions that have come up. So Jeff, I don't know if you're going to help walk through those with me.
Sure. Thank you so much, Olivia. A lot of great information as always. So I was remiss at the very beginning. There is a chat box on the right-hand portion of your screen. If you wanted to ask any questions, now is certainly the time. You have a great attorney here ready to answer any question that you may have now or ever have had about estate planning. So please feel free to note your questions and I'll be sure that they get to Olivia and we'll go ahead and get those answered. Before we do that, and as you're noting your questions, Karen, is there anything that you wanted to say in closing?
I just want to thank you both so very much for this very insightful overview. This is a fantastic overview of wills and so forth, and thank you both so very much. And I'll look forward to hearing questions. People are always welcome to send questions my way or Dr. Buchanan's way as well, if you can't think of anything at this moment. So, but thank you so much, Jeff and Olivia. This is fantastic.
It's our pleasure, and again, we appreciate your partnership and Dr. Buchanan's partnership and the Lutheran Village at Miller's Grant and Carroll Lutheran Village, so we appreciate it. So we do have one question to start off with, and that question is, Olivia, discussing how to select an executor, in particular for a person that has no spouse and no children and no siblings. Can you talk a little bit about that?
Yes, thank you, Jeff. And that is a common concern. And really it goes beyond even just the personal representative or the trustee who will handle things after death, but that's also a concern and an issue that many people have with regard to the advanced medical directive or the financial powers of attorney, is who is it that I'm going to entrust with this role and this responsibility, particularly for people who perhaps don't have a spouse or adult children or siblings, but even sometimes for people who do and just don't feel comfortable either putting that burden or entrusting that responsibility to those people. So that is always part of the counseling. The answer, the simple answer, is that I always go through all the different options that I can think of, including friends, which sometimes, people may assume that this is something that should only be entrusted to a family member, but that's not always the case. Sometimes friends are a good option, or at a minimum, people can always utilize professional services for these roles. So many clients who have not had anyone else that they've felt comfortable naming have named me, or sometimes their CPA who they've had a long-standing relationship with, or another attorney or financial advisor. So there are professionals who can fill those roles if there's really no good personal option.
Thanks, Olivia. There was a question directed, I guess, more towards me regarding getting a copy of the presentation today. And yes, I will be sending that out as well as a link to today's presentation. We found that a lot of people like to share it with family and friends that weren't able to attend and may have found it valuable. So I will be sending that out, and you'll have that by tomorrow morning. Any other questions? We have another one. How often should the documents be updated? A great question for Olivia.
Thank you. That is a great question. And that is something that I always try to emphasize when people are establishing their estate plan and they think, yay, now I'm done with this. I can check this off my to-do list and I never need to think about it again. Unfortunately, I have to be the bearer of bad news and tell people that is not the case. And what I really recommend is that you revisit and update your estate plan at a minimum every 5 to 7 years. If circumstances change in your specific family or assets or health or anything else in your life that you think warrants changing the documents, then we should do that as soon as you feel that way. But if everything is going on as normal and there are no significant changes, I still recommend revisiting and updating at least every 5 to 7 years, because that way you're sure that your documents are up to date with the law, which comes as no surprise to anyone, changes all the time, especially tax law. And the only way that we're able to make absolutely sure that you have documents that are current and that are going to work according to your preferences and your needs is to revisit them about every 5 to 7 years.
Very good. Thank you, Olivia. Any other questions? Going once, going twice. Well, okay. We'd like to thank you for being here today. If you have any further questions that come to mind later, you have Olivia's information there, and it'll be in the, actually, wait a minute. Looks like we have one more. Just under the bell. How long might it take to get these documents established, Olivia?
Well, that is a great question. And of course, right now we're dealing with nuances that we didn't normally deal with, but in light of the stay-at-home orders and all of the other things that we're doing to stay safe, what we're currently doing is, as much as possible, having meetings to discuss the documents and to really get things in place using our video conferencing tools, as well as, of course, just good old phone calls and email. So realistically, and it depends on the type of estate plan, someone who wishes to do a very simple, very straightforward plan, that's something that can be implemented fairly quickly, versus a more complicated plan that may involve the revocable trust or asset protection trust planning, and that takes a bit longer. But what we are able to do for people who do wish to implement the trust type plan, but who are perhaps panicked at not having any documents in place at all, I'm always very willing to get in place what we call a stopgap will, which means that you've at least got a will signed and in place in case the worst happens. And then we can proceed with really working through the trust and discussing the nuances with that. So to answer the question, under current circumstances, I'm finding that as long as, if we're not dealing with an emergency, if I am dealing with an emergency, I'm always willing to accommodate and move as quickly as possible. But under normal circumstances, if we're not moving under any sort of emergency, then getting documents in place on the simple end, we're looking at 3 to 5 meetings to be able to review everything and get it signed. And at the long end, we're looking at usually 7 to 9 meetings to really review everything and get it in place.
Thanks, Olivia. There also was one other question about downloading the slides. In the handouts, there is the PowerPoint located in the handout section. Some people have some problems downloading that, which is why I do send it out. But if you do click on the handout section, you should be able to pull up the presentation. And if you are able to save it to your computer, you're more than welcome to do that. But I certainly do follow up with the video link and presentation just as a courtesy to everybody as well.
That's fantastic. I will also have a copy in case anybody wishes to stop by my office. This is Karen McNamara.
Hey, any other questions? Okay. Well, thank you very much for spending some time with us today. We appreciate it. Please stay safe and be well.
And thank you again from Janet and myself as well. And we wish everybody to stay safe and to please stay healthy as well.
Absolutely. Thank you so much. Thank you. Take care.
Bye-bye.
Bye, everybody. Thank you.